Good evening. It's 7 o'clock and we have 62 people so far. So I'm going to welcome everyone and introduce myself. I'm Beth Ncjw, facilitator for the Ncjw Chicago North Shore Spotlight, a monthly series of programs about social justice issues. I'll open by stating that Ncjw Chicago North Shore acknowledges with respect that the land we are on today is the traditional and ancestral homelands of the Kickapoo, Peoria, Potawatomi, Miami, and Ho-Chunk nations and peoples. A year ago, due to the impact of disinformation and misinformation from nefarious sources that was being spread on social media by artificial intelligence, we wanted to understand how this operates. We also believed that the impact of this and the solutions could not be understood by only one program. We invited Ncjw South Cook to join us and Salon, another educational program of Chicago North Shore, to join us. In our first program, we explored how propaganda in general works through the lens of the Holocaust with Chuck Myers and Steve Lukert. Last week, David Goldenberg, the Midwest Regional Director of the Anti-Defamation League, helped us to understand how artificial intelligence is able to choose the news and posts that you receive on social media and spread them on steroids, unbeknownst to you, whether it be anti-vax information, false information about political candidates, or anti-Semitism. Tonight, in our final program in the series, First Amendment Rights and Regulation, we'll learn what can be done to intervene. We're honored to have Jacqueline Carroll, Bret, Schafer, and Rosenberg as our speakers in a panel discussion. After I give a very brief introduction of our panelists, each will talk about his or her area of expertise, and then Jacqueline, the moderator, will begin the conversation. You can read the full bios at the Ncjw website that I'll put in the website shortly. Jacqueline Carroll is an attorney, a human rights advocate, and a storyteller. After a big career in the theater, she obtained her law degree from Loyola University Chicago School of Law. She has very recently, like last week, been named Midwest Director of the Simon Wiesenthal Center, so we congratulate her on that. Bret Schafer is the Alliance for Securing Democracy's Media and Digital Disinformation Fellow. He has a BS in Communications with a major in radio, TV, and film from Northwestern University and a master's in Public Diplomacy from the University of Southern California. Rosenberg has over 20 years of experience as a media lawyer. He graduated magna cum laude from Cornell Law School. He's the author of The Fight for Free Speech, a book published in 2021, and he's also an Emmy-nominated documentary filmmaker and teaches media law at Brooklyn College. Jacqueline, I'm going to turn this over to you so you can tell us a little bit more about yourself, and then turn it over to Bret and Schafer and start our wonderful discussion. Thanks so much.
Well, first, I'd like to thank Beth for the kind introductions and to thank the National Council of Jewish Women for including me in this panel. My legal background includes litigating over 50 civil rights cases in federal court. But as of last year, my focus has been mainly on advocating for human rights and combating anti-Semitism. Last week, I was honored to take a job with the human rights organization, the Simon Wiesenthal Center, to be the Midwest region's senior manager for programming and development for our Mobile Museum of Tolerance. That said, I would like to add that for the purposes of this conversation, the opinions I am espousing are my own, and I'm not speaking as a representative of the center. When it comes to free speech, one of the seminal cases is the National Socialist Party of America versus Village of Skokie, or as many people know around it here, the Nazi March in Skokie. It started in 1977 with Frank Cullen, the head of a neo-Nazi group's desire to hold a march in the village of Skokie, a suburb which we know has a significant number of Jewish people. Many of them are Holocaust survivors. Back in 1977, many Holocaust survivors did not speak about the Holocaust, not even to their families. The topic was verboten. The idea of Nazis marching on the streets of Skokie caused a lot of psychological turmoil and caused survivors to speak up and tell their stories. They pled with legislators to stop this event from occurring. In response, the village tried different tactics. They passed 3 ordinances to prevent the event or future similar events. These ordinances prohibited people from wearing military-style uniforms, prohibited distribution of material containing hate speech, and required a large insurance bond. They also filed an emergency injunction seeking leave to prevent the marchers from wearing their Nazi uniforms or swastikas or distributing materials which incite or promote hatred against persons of the Jewish faith. The Circuit Court of Cook County granted the emergency injunction. The ACLU, representing the neo-Nazis, appealed. The Illinois Appellate Court and the Illinois Supreme Court sat on the case for a little while and then denied the stay of the injunction. The ACLU appealed to the United States Supreme Court. Now, the Supreme Court's opinion is very short and mainly procedural, but the court said that if a state seeks to impose a restraint on First Amendment rights, it must provide strict procedural safeguards, including immediate appellate review. Without such review, must allow a stay of injunction. Now, the case hopped around a little bit in the court system, but the injunction case ended up back in the Illinois Supreme Court. Now, before we go on, I want to show the actual text of the First Amendment. Kim, if you could play slide 1, please. So the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people to peacefully to assemble and to petition the government for a redress of grievances. What the First Amendment does not include, if you could play panel number 2, please. The speech that's not covered by the First Amendment include obscenity, fighting words, defamation, child pornography, perjury, blackmail, incitement to imminent lawless action, true threats, solicitation to commit crimes, and plagiarism of copyrighted material. Thank you. Hold on 1 second, I'm sorry. So if you notice, hate speech is not listed as an exception. The village argued that the swastika was fighting words, and the Illinois Supreme Court disagreed and found that the display of a swastika was a symbolic form of free speech entitled to First Amendment protections. The court noted that the Jews in Skokie simply could not show up to the march. So most people know that a march occurred, but most people don't remember that the march didn't actually occur in Skokie. It occurred in Chicago. And very few people know the reason why. And the answer is, my father stopped it. My father was the state senator representing Skokie at the time. Many of his constituents met with him and said that they survived the Holocaust, but watched their families get slaughtered by the Nazis. They said that they had bought guns and were willing to go to prison and even die rather than let a Nazi march near their homes. They felt they couldn't do something about it before, and they were willing to do something about it now. My father met secretly, my Jewish father met secretly with Frank Holland and Secret Service and people from the DOJ. And my father told Frank Holland that the Supreme Court says he's allowed to march, and he's allowed to march. But if he did, there would be a massacre, and the next marches would be their funerals. And in the end, they didn't march in Skokie. Now, like my father, I am a vast defender of freedom of speech, and I believe that it has to be protected. But I also believe that there needs to be people to stand up and protect victims of hate speech. Thank you. I believe that Bret is next.
Thank you, Jacqueline, and thanks so much to the Ncjw for having me. I'm coming to you from a basement in DC, but I'm originally a Chicagoan, so it's always nice to do a Chicago event, even if we have to do it remotely. So my work at the Alliance is primarily focused on detecting and deterring information operations conducted by China, by Russia, by Iran, to create social and political upheaval on social media. Also just upheaval in democratic countries, so that's including, but not limited to, election interference. So I also look at broader questions that sit sort of at the intersection of tech and national security. And the question that is always asked in relation to my work is, how do we stop this? How do we get rid of disinformation and other harmful content? And that's really not the right question to ask, because the question that we need to ask is, how do we mitigate online harms without creating a bunch of cascading unintended consequences? Because if the question is just how do we get rid of bad stuff online, the answer is pretty simple. We should do what the Chinese did. I mean, there are regulations, there are technical tools that can drastically reduce the more harmful content online, but they come at a free speech cost. And to be honest, after doing this work full-time for 4 years, I'm a little bit less sure today about how to correctly balance the need for content moderation and regulation with our desire to keep an open, democratic internet. Because two things after doing this work for quite some time are now abundantly clear to me. One is that there are significant and catastrophic real-world harms created by hate speech, propaganda, political, and health disinformation. And if there are any doubts about that, I think those doubts have disappeared during the pandemic and after January 6th. And that's just looking at the US. I mean, overseas, we have seen genocides, mob violence, and other real sort of visceral horrors that have been facilitated by digital platforms. So it's absolutely clear we need to have content moderation. To be clear, content moderation is what the platforms do. So those are Facebook and Twitter's internal teams who are moderating content on their platforms, basically enforcing their terms of service. But we also need regulation, which is of course what the government does. And I'll talk more tonight about where I think the role that government should play should be in fostering a healthier internet, which in my opinion should not often directly address content, except with a few limited exceptions. But the second part of the speech versus the need for greater regulation tension that makes me a bit cautious about how we should go about regulating speech is that efforts to moderate and regulate speech online have played into the hands of authoritarians trying to suppress legitimate speech at home. They've been used for political talking points to further divide and radicalize us. And perhaps most problematically, it has pushed people from mainstream platforms to the darker, more problematic and more radical parts of the internet. I mean, we saw this after January 6th. One of the big movements was to try to push conservatives off of platforms like Facebook and Twitter to places like Parler and Gab and 4chan and 8chan, where truly, truly problematic stuff occurs, often with no policing. And so when I think about how to tackle online harms, I do so from a perspective of trying to fix the architecture of the internet and to try to address issues related around coordinated inauthentic behavior online. So coordinated efforts to manipulate us, rather than trying to address whether or not an individual piece of content or a category of content should or should not be removed from a platform. And I'd sort of caveat that again by saying that I look at disinformation and propaganda. So I'm often not dealing with the worst parts of the internet. And for the most part, when I look at the problems online created by Russians, this tends to be a behavioral problem. If you just look at the speech, 99.9% of it would be protected if it were put out by a genuine person. So what I deal with are Russians sitting in St. Petersburg pretending to be Black activists, trying to burrow their way into activist communities, manipulate them, radicalize them, etc. So this is more of a behavioral problem than a content problem. But clearly, there are cases where the content itself is a problem. With child pornography, it's quite clear. With terrorist content, it's usually clear, though I'd stress that while it's obvious that a video of a beheading falls outside the area of protected speech, there are plenty of governments who have used the notion of terrorism or have cracked down on terrorist content as a way of suppressing legitimate speech domestically. And then there's sort of a sliding scale where things get murkier and murkier when you talk about hate speech and harassment and misinformation and disinformation and other online harms. So the final point I want to stress is just the scale of the problem. So Facebook alone employs more than 20,000 content moderators around the world. They remove roughly 10 million pieces of content and accounts every month. And oftentimes these decisions are being made by individuals sitting in office parks in Phoenix or Bangkok, who are being forced to make decisions, really consequential decisions, every 3 seconds that the Supreme Court hasn't really decided on in 200 years of jurisprudence. And so it's just really complicated. And that's not an argument to say we should do nothing. We should. I mean, there are areas where we clearly need better regulation, and the platforms need to be better at moderating content. But I just want to stress that over-moderating and over-regulating can sometimes play right into the hands of those who are trying to manipulate us, trying to divide us, and trying to radicalize us. So I will leave it there and turn it over to Ian, I think.
Thank you, Bret, and thank you, Jacqueline, and thank you to the National Council of Jewish Women for inviting me. I have family in Chicago, but I'm speaking to you today from the Lower East Side of New York. So I've been a media lawyer for over 20 years. I currently work at ABC News as Assistant Chief Counsel. But it wasn't until a few years ago when I decided to write a book. There's my book. It wasn't until a few years ago that I was having a conversation with my kids at the dinner table about their interest in participating in the National School Walkout to protest the lack of gun safety measures in our society. And they were asking me very practical First Amendment questions. Did they have student speech rights? What would happen to them if they skipped school? And what did this mean? And how does this play into our First Amendment rights in general? And I realized from having conversations with them, they were about 10 and 12 at the time, that I could convey First Amendment law in a way that was simple, but without dumbing it down. That wisdom indeed can be condensed, but it does not have to be just for children. It can be for, and it does not have to be just for lawyers. It can be for anyone to understand. So I decided to write The Fight for Free Speech to try and explain to people in a general interest way who were not lawyers what our First Amendment rights are and what they entail. So each chapter in The Fight for Free Speech begins with a contemporary question, from National School Walkout or Can Colin Kaepernick take a knee, to Nazis marching in Charlottesville, the more contemporaneous example of Nazis and their hate speaking in a mass demonstration, to also social media and the problems on our internet, speech problems on our internet. So I begin each chapter with one of those questions, and then I look to the stories of the real people who fought for their rights to speak all the way up to the Supreme Court that led to a decision that answers those questions. So I hope that by providing this guide, I like to call The Fight for Free Speech a user's guide to understanding our free speech rights. I hope that by providing this guide, that people on all sides of the political spectrum will begin to understand what their rights are before they start seeking change. Now, it's, you know, I want to, in my conversations tonight, I want to focus both on what the law is right now, and then mostly leave it for other people to talk about what the law should be. Because I think we can't really engage in any kind of productive discussion of what the laws should be until we know what the laws are today and how people have fought for those rights all the way up to the Supreme Court over the course of the last 100 years, basically. And the people, I don't call them necessarily heroes, because some of them are not great people, but the people who are the First Amendment pioneers in these cases are often not from the political spectrum that we might think of today. So, First Amendment law is interestingly something that really crosses political spectrums and political divides. So we have some of the great free speech cases coming from the more liberal justices of the past, but then we have Justice Roberts today, who considers himself one of the foremost champions of free speech and ever on the court. I'm not sure I would go as far as Justice Roberts believes, but he is definitely a supporter of free speech rights. So when we talk about internet regulation or social media regulation or hate speech regulation, I do want us to begin by talking about what is and what is not protected before we try and start fixing the problems. And then hopefully, and those are all three things that I talk about in my book. Hate speech, which, as Jacqueline pointed out, is protected under American free speech law in contrast to what we have in Europe. Social media protections, where the court has explicitly said that there is a First Amendment right to access social media, and then sort of the internet in general. And the future of internet policy, and whether we need to treat the internet as different from everything that has come before it, different from print and radio and television and movies, or similar to that, to those other medium, and therefore essentially that the government must keep their hands off regulation. So I think all of these issues are answered in my books, and I hope to get to chat about them with you all tonight.
Thank you, Ian. Well, I'm going to start off this discussion asking some questions, but I think, Ian, you just kind of asked your own question about what is the status of the law right now. Before we go into regulation, what is the status of the First Amendment right now, and speech, what's included, not included?
Right. Well, as Jacqueline helpfully pointed out at the beginning, looking at the text of the First Amendment, it begins by saying that the government shall make no law. So we have to remember that originally that just meant the federal government through the 14th Amendment that's been applied to the states. But when we're talking about First Amendment protections, we are talking about the government, meaning federal, state, or state actors, which is often the state actors that people are interested in are often public school employees are the most common state actors other than government officials. Those people are generally prohibited from regulating content in any way. Those government actors cannot regulate hate speech content, they cannot regulate online content, and they cannot regulate social media content. So the state of sort of First Amendment law in a nutshell is that we have essentially no government regulation of speech. The FCC is an exception, and we can talk about sort of exceptions as they become interesting to people, but the vast overarching principle of the First Amendment law that we have today is that government cannot engage in regulation of speech content. And the reason for that is, besides sort of the doctrine of over 100 years of case law, but I think sort of the best, most practical reason of that is that for people to understand is who will decide? Who will decide what is good speech and bad speech? I think if the last previous administration has taught Democrats anything, is that we certainly wouldn't have wanted the Trump administration deciding what truth and content should be. Perhaps some Republicans feel the same way today about President Biden's administration. But who is to decide and how it is to be applied are really the crucial questions to sort of always think about when we get tempted to say, well, that speech, I'm in favor of free speech, but that speech is bad, and I don't want that speech. Because just at the same time the Nazis were being, the issue of Nazis marching in Skokie was coming up, contemporaneously with that, Dr. King sought to march in Illinois, and people used the very same arguments that they were using to stop the Nazis as they were using to stop Dr. King. Now, of course, their messages have no equivalency there, but the court's view is that, and this is as recently as the Roberts Court, is that we cannot regulate speech even for those who espouse the thoughts that we hate. And in that is what the law is. And I would also take the next step in saying that is what the law should basically be.
Bret, do you have anything to add?
I would largely agree with that. But I would also take, our work looks a lot at Europe. I mean, I work at the German Marshall Fund. So Germany, we tend to look at having sort of similar values at this point in terms of a free speech environment. But it's very different. I mean, Ian pointed this out. The sort of European definition of free speech and the American one are not the same, because in the US, as Ian pointed out quite clearly, we tend to look at it as keeping the government out of speech and not having government regulate speech. Where in Europe, there is that principle, but there is also the idea that the government should have a role of protecting those whose speech may be infringed upon by other groups. So if you're talking about minority groups, if you're talking about those who may be the targets of harassment, there is this idea that government should protect those whose speech is threatened by others. Germany is obviously one of the most restrictive kind of the free speech environments we think of in the West for obvious historical reasons. And so, you know, when we think kind of globally, which is how I think we have to think when we think about the internet, the starting point for how we regulate the internet, if again, we want to keep it open and democratic, is that it's really complicated even to get those we consider to be on the sort of right side of the free speech barricades on the same page. And then, of course, you have the bad actors on the other side of the barricades. So I'm talking sort of speech bad actors, China, Russia, Iran, others that significantly regulate the type of speech that can exist online. They shut down platforms. So my only addition there is how complicated this is when you get to a global perspective, because it's complicated in the US and it gets more and more complicated when you start adding in other international actors. And of course, many of these global platforms have to adhere to local laws. So they're dealing with this sort of patchwork quilt of speech laws that make content moderation just an enormously difficult task.
I want to go back to, you know, it's a government actor, right? I think a lot of people get very confused when they say that they said something and then they got fired by their employer. Would one of you like to talk about why there's not a free speech issue there?
Well, I'm happy to start with that. So again, it goes back to the text of the First Amendment. I said the government, but it's really Congress shall make no law abridging the freedom of speech or of the press. People's speech rights, people don't realize this, as you correctly point out, but people's speech do not have free speech rights in connection with their employer. In almost all circumstances, because the First Amendment doesn't get involved because there's no government actor. So, so people often think that freedom of speech means freedom from consequences, and that is not true at all. And in fact, many of the pioneers that I talk about in my book, they fought all the way to the Supreme Court to win a right to speak, but they often were subject to, and they generally won those rights, but they often were also subject to lots of other types of punishment, losing their jobs, being criminally prosecuted, getting death threats. In the case of Mary Beth Tinker, a young anti-war activist who gave us our student speech rights. So freedom of speech does not mean that you are free to speak and keep your job, or free to speak and not be prosecuted for espionage. It means that there is a premium in our system on letting messages be spoken and letting them be heard. And then after that, we have a lot more regulation and a lot more consequences. So one of the sub-themes of the fight for free speech is that private employers can generally do what they want to you in connection with your speech rights. So the NFL has a right to control Colin Kaepernick's speech, but a student athlete who is at a public school who's taking a knee has a First Amendment right to not speak. And in fact, the First Amendment will protect those students who would choose to not participate in the Pledge of Allegiance, thanks to a fascinating series of cases involving the Pledge of Allegiance and Jehovah's Witnesses. So it's very important that we look at the same exact action in a different context, in the private employer versus the government context. Has very different results. And the government is restricted from controlling your speech, but private employers are not.
Now, Bret, unless you have something to add, I want to follow up on that in terms of school, like people who are at school, like the Texas cheerleader case, for example. I know that I believe that the National Council of Jewish Women has talked about this before, but that occurred off campus. The statements made were not bullying, they were not harassing, and they occurred off campus. What is the difference between being off campus versus on campus, and what specifically was said that made it, that made it okay for her to say?
Well, I'm happy to talk about that too. The case is called Mahanoy versus BL. BL ended up being Brandy Levy. This was a case just decided by the Supreme Court this year, and as Jacqueline mentions, involved, people might know it as the cursing cheerleader case. There was a cheerleader, high school cheerleader, who didn't make the varsity team, and then off campus on the weekend on Snapchat, which is a social messaging app in which your messages eventually disappear. I won't curse for this crowd, but she said, F cheerleading, F school, F everything, essentially. People saw those messages, they brought them to the school administrators, and they kicked her off the team. And the case goes all the way up to the Supreme Court, decided this June, and people were very concerned about why the court was doing this, because the key precedent, which is the one I talk about in my book, and which I was just alluding to, is called Tinker versus Des Moines. It involves a young woman, Mary Beth Tinker, who's a middle school student, who wore an armband, a black armband, to protest the Vietnam War and to honor the dead on both sides, both the Vietnamese and American casualties, which is a very radical notion at this time in the war in Iowa. And what the result of that case was, the Supreme Court said that students and teachers don't give up their constitutional rights to free speech as they pass through the schoolhouse gates. So what was interesting in Mahanoy was the court is talking about student speech outside of the schoolhouse gate context. And what the majority ruled 8-1 was that although there might be some circumstances in which school administrators can control off-campus speech, as you sort of alluded to, perhaps at school-sponsored events or cases that involve violence or intensive bullying, this was not one of those examples. And in fact, schools, Justice Breyer wrote, I'm paraphrasing here, are laboratories for democracy, and that if and have an obligation to not only allow students to participate in the marketplace of ideas, but to sort of protect the marketplace. Because if students have their speech controlled to some degree on campus as well as off campus, then that eliminates students' speech and the right to listen in sort of all contexts. So it's the most significant pro-student speech decision in 50 years. It's the first time in 50 years since the original Tinker decision when the Supreme Court has backed student speech rights. They've been pulling back in different contexts, and in vulgarity and drug context and in student publications. So this is a really important decision. It shows how even our very conservative court right now, the conservatives and the liberals joined together to protect student speech rights, and they sort of punted the tough question of when off-campus speech can be regulated. But the short version is in very narrow circumstances, and the court wasn't ready to go there. So this is, I think, fits into our bigger picture of saying that the court is once again reluctant to allow, even in the school context, any type of micromanaging or regulation of student speech, which is protected, but has sort of a lesser degree of protection than adult speech.
So I guess my next line of questioning kind of delves more into what speech deserves greater regulation than others. And does hate speech deserve more regulation? Should it be like obscenity? In the sense that obscenity is not defined, right? There is no specific definition of what obscenity means. And there's no specific or clear definition as to what hate speech is. It's kind of like, I know it when I see it, I know it when I hear it. But could hate speech laws mirror obscenity laws by employing a test?
Brett, I'll let you go first since I've been.
Yeah. Well, this one, yeah, this one is also, this is very much a Bret question.
I will kick the sort of more legal questions to Ian because I'm not a legal scholar. But I would point to some of the challenges there coming from a practitioner perspective of what you tend to see in communities that engage with extremely problematic points of view. It tends to be done often in a very coded language. And so even if you sort of clearly define what is sort of outside the bounds of protected speech, for the person who is moderating or regulating speech on a platform, that is often very difficult to untangle if you look at the sort of coded language and the memification of online speech. So I'm thinking of communities that are extraordinarily misogynistic. All of their speech tends to be through coded language, particularly if they're on a platform where there is some form of content moderation. They know the lines they can't cross. And so they have created this entire lingo to sort of circumvent the rules put in place by platforms. Obviously, on platforms that don't really have any content moderation rules, like it tends to get a little bit more aggressive and overt, but still they're often really, really sort of dangerous or insightful kind of speech is done in a way that would be tough to fully understand unless you are deeply immersed in these communities. And so that just points to the difficulty, for instance, if you're the Germans, and this is, Jacqueline and I sort of talked about the German law, Ncjw, which, as I mentioned, the Germans have a far more restrictive sort of free speech environment than we do. And things like Nazi propaganda are forbidden by law, along with many other things that sort of go down a sliding scale of what would be more difficult to easily identify as existing in a world of something that is not protected speech. And the problem with the Ncjw, so what Ncjw is essentially is it made the platforms liable for speech that was illegal offline. So in some ways, it seems like a very clear, kind of straightforward thing. Again, though, you get to the scale problem. There is just so much that is out there on digital platforms that a German could access, that the scale of takedown requests was fairly overwhelming for these platforms. And then you also add in, if you're now making a platform liable for a bit of speech where there's still some ambiguity there. I mean, in some cases, it's very clear, obviously, but in others, it's not so much. But when you draw a line and say that within 24 hours, if you don't take down this piece of content that could be determined to be illegal under German law, you are fined a certain amount of euros, the reaction from the companies is to take down more and more content because they're going to err on the side of not getting a huge fine. And so some of the blowback to that law is when the companies have put out their progress reports, they just show that they're taking down more and more and more content each month, as if that is indicative of progress. And maybe it is, but you can't get at every individual post. And the fear is that when you put in place laws like that, the platform response is, we're going to protect ourselves. And so if it is anywhere near the line, it comes down. And so again, that's just the one sort of bit of warning of when you get into saying that the content itself is illegal. Again, with a few exceptions that I think are pretty clear under American law, it gets complicated. And I think it incentivizes more restrictive policies and more takedowns from platforms.
Well, do you want to go into, or sorry, Ian, do you want to speak?
Well, I was just going to, that's very helpful practical look. I was just going to give a moment of a theoretical response to your theoretical question from a legal perspective. You know, yes, there is no constitutional prohibition on creating a test that would limit hate speech in theory, but that is not the direction the court has gone for years and even very consistent, very recently. And yes, we do restrict other forms of speech. And in fact, you know, very sophisticated scholars like Marie Matsuda and Richard Delgado, who are both leading critical race theorists, you know, have basically provided suggested tests for limiting hate speech or limiting First Amendment protection, when we could, you know, say that the First Amendment protections for hate speech could be, that veil could sort of be pierced. However, that is not what the court has said consistently. And the difficulty, I think, that Bret was alluding to, besides the sort of legal theoretical difficulty, which is what I said before that Justice Roberts has talked about, which is that if the First Amendment means anything, it means protecting the thoughts of those that we disagree with. Going back to the Abrams case, which is our sort of modern conception of First Amendment law, Justice Holmes writes about the marketplace of ideas. He creates that notion and saying, the best test of truth is the power of an idea to get itself accepted in the marketplace. Now, at the time, the speech that was being controlled were anarchists, and that now seems sort of charming and quaint to us, but in that day seemed as radical and as hateful as perhaps Nazis or other racists might seem to us today. So there is this long tradition that we must protect the speech that we hate, even if in theory we could come up with some test that might protect certain forms of speech and not others. And I will just say, since we've talked about the German model a number of times, which is, as Bret and you have pointed out, is very difficult, very different. There's also an excellent book by Nadine Strawson, former president of the ACLU, and her father is a Holocaust survivor, that's called Hate. And then I always forget the subtitle, but it's something like Why We Must Fight It with Speech Rather Than Censorship. And she spends a lot of time in that book sort of dissecting the inefficiencies of the European models of trying to regulate hate speech, both pointing out how hate and racism and anti-Semitism are still flourishing in Europe, and also pointing out how often hate speech codes are used to persecute the very minorities that we would think the laws are trying to champion. And I think this goes to Bret's point about the difficulties of implementing what seem like simple rules. So yes, in theory, we could construct a way of doing it, but no, that is not our constitutional tradition. And I would also argue, no, it doesn't work in practice, that the European models have largely failed in terms of the outcomes that we might be hoping for.
But don't we also have a responsibility to protect people as much as we should have responsibility to protect speech? I mean, the whole point of hate speech is to degrade, to dehumanize, to stigmatize, to harm people and cause them emotional reactions. There are laws, and I think my issue is, I was a prosecutor I was an assistant state's attorney for 11 years, 6 years as a prosecutor, and I specialized in going after sex offenders of children. And then I went into civil rights litigation for 5 years, but I always believed in protecting the victims and protecting the minorities. And I feel like there needs to be a better balance, because if you look at Tree of Life, Poway, Christchurch, all of those people that created these mass shootings, they were indoctrinated online and they put hate speech manifestos online prior to committing these acts. So shouldn't there be some type of regulation or some type of monitoring or some type of censorship to prevent someone from getting to the point of becoming a mass shooter?
Well, I would say there's sort of two key thoughts or points you're raising. One, yes, the victim. There are a lot of free speech advocates who I otherwise agree with, who I think are too cavalier about dismissing the harms of hate speech. They are real, they are significant, and they are terrible. I don't think that we gain anything from a First Amendment perspective by trying to dismiss or diminish those real victims and real harms. However, to your second point, I would say that to prevent those tragedies, what we needed to do was not to control their speech, but to control their access to guns. So when we're talking, which is a topic for a different panel, and it's not my area of expertise, but I think what it points out is that yes, I too care deeply about the victims of both, of course, racist and anti-Semitic violence, but also just racist and anti-Semitic speech. The question is whether controlling that speech prevents real physical harms. I'm not sure that it does. And also, I think on balance that although right now we are seeing a rise in protections for the radical right or hateful actors. For so long in our constitutional history, the people who were being, whose speech was attempted to be controlled were Black people, were minorities, were anti-war activists, were gay rights activists. So I don't think we want to lose sight of our recent history, which is again why in the fight for free speech, I'm so interested in sort of telling the stories of historical examples of First Amendment fights, because the sort of politics of them have changed. And I want people to look at both sides of the politics before they're so interested in abandoning the protections that we've won, even if it's for some good reason, like trying to protect victims.
I mean, there have been some limited carve-outs to protect victims. So SESTA, which I think is Stop Enablers of Sex Trafficking Act, goes at Section 230, which we haven't talked about yet, but I'm sure we'll.
Which is my next question for you.
Okay. So Section 230, and again, I'm not a legal scholar, but Section 230 essentially is sort of known.
Do you want to explain what Section 230 is, like with the federal, you want to?
So Section 230 is considered what created the, it's part of the Communications Decency Act. It is the part of it that is attributed to creating the internet as we know it, which what it essentially says is a digital platform is not liable for content posted to that platform by a third party. So social media absolutely could not exist without Section 230 or something like it, because otherwise your crazy uncle in Texas who says something libelous about, you know, another relative or employer they dislike, that could make the platform liable for speech, or, you know, obviously worse examples than that, but there would be no way for social media to exist without Section 230. What's interesting about Section 230 is when I started this work, this was a big target of Europeans who really wanted to go after Section 230 because they found Section 230 to be way too permissive and to be essentially what allowed the platforms to get away with murder. And slowly over the last several years, Section 230 has now become something that's really in the crosshairs of Trump and parts of the right for entirely different reasons, thinking that Section 230 is allowing platforms to take them down and to take down right-leaning content with really no consequences. So Section 230 is kind of at the core of these debates, I think. And there are multiple pieces of legislation right now that are talking about ways to amend Section 230. SESTA was one of them. So SESTA essentially said the platforms are liable if they do not put in a good faith effort to remove content that is associated with the sex trafficking, child pornography.
The key thing is sort of knowingly permitting content that involves sex trafficking, because that was very much the speech protective limitation that was put in, and I think was an effective one. There's a lot of free speech people who were up in arms about that. It didn't trouble me too much because I did think it was limited that way, that basically websites like Backpage, which used to be sort of an online marketplace for many things, but also was accused of being, and I think there's a tremendous amount of evidence of being an online marketplace for sex trafficking. They often said, well, these are third-party ads. We don't know anything about it, or we can't do anything about it. But they clearly knew through various different reasons why these ads were facilitating sex trafficking, and in fact, they sort of acknowledged that. So that is a very small carve out to Section 230, and I do think that it's a constitutionally sustainable one. But I would like the Electronic Frontier Foundation, which is sort of the ACLU of the internet, and other advocates, I would be very concerned about the efforts to amend Section 230. And they're often, people use Section 230 as a boogeyman that they think if we fix that, we can fix all of the internet. But really, Trump's claims about content moderation really have nothing to do with 230, and it's totally a red herring. And some people on the left think that they can fix hate speech by tinkering with 230, and I think that's also wrong. A lot of times I want people to focus on not to say don't engage in change. I think there's a lot of regulation actually that would not be First Amendment intrusive that we could force social media companies to do. We could have greater disclosure laws, we could have antitrust laws, we could have making their policies more consistently applied. I don't think any of that would necessarily interfere with the First Amendment, but where I'm going here is that the fact that people want change, we should know what could be a successful tool for change, and I don't think Section 230 is the place to try and start poking to bring about those changes that people want.
So I want to just for the audience that it's Section 230 of the Communications Decency Act of 1996, in case you want to look it up, or 47 USC Section 230. And what's really interesting, because one of my questions was going to be, is Section 230 more of a shield or a sword, or a little bit of both?
Interesting question. I mean, it is a shield by definition, in that it protects, as Bret said very clearly, protects internet platforms, it protects social media companies, it protects bloggers. It's not just, the CEO of Twitter, it also protects anyone who has a blog. If you have a comment section on your blog and somebody says Hillary Clinton is a murderer on that, that kind of false libelous statement, you're not going to be, not that she would sue for that, but if she wanted to sue, over that, she would sue the person who posted it, and she would not be able to sue you, the blogger. Similarly, the New York Times, ABC News, they are responsible for the content that their journalists and that their employees put out online. But in the comment section, where anyone can add in their comments about an article, that material is people can publish whatever they want there, and the platform doesn't have to worry about it. So that is indeed a shield. I think there are other ways that you could make the metaphor work as a sword, but I'll say that in large part, or almost entirely, it is an effective shield.
Bret, do you want to comment on how it could potentially be a sword?
Well, yeah, I mean, Senator Wyden, who's one of the original authors of Section 230, has argued that it actually allows the platforms to moderate their platforms as they see fit, and that they are allowed to take down content that doesn't fit with their values, which is, I don't know if, again, not being a legal scholar, if that's totally correct. I mean, I think this would be protected by sort of First Amendment issues, that like the New York Times doesn't have to publish things that they don't want to publish in the same way that like a Christian site online is going to have different sort of terms of service and different rules than a site that like Twitter that allows most forms of speech, and they're allowed to take down content without there being any consequences. I did want to hit on sort of one point Ian made, though, that I think is really, really important when he talked about it also protects bloggers. I think that's critical to discuss. Is the internet is not just Google, Facebook, and Twitter. They dominate a lot of it. And we could, I think, get into a very long conversation, and Ian also teed this up about antitrust, because when you talk about, Twitter has its own rules when they decide to take someone down, even if it's somewhat arbitrary, Twitter is allowed to make those rules. They built the platform, they can decide who's on it, who's not on it, what kind of speech they allow on it, what kind of speech they don't allow on it. However, I mean, I think there is an argument to be made. If you are banned from Facebook, Twitter, YouTube, you are running a business, you're trying to run for political office, you're kind of out of luck. But that's a sort of conversation for another day, because it gets into the sort of antitrust discussion. But I do think it is really, really important to think of the wider internet. And go ahead.
Oh, I just wanted to tie that up to something you were saying before about Germany. When Trump, and you're absolutely right that Wyden is correct that Section 230 does enable platforms to moderate their content. That's another red herring that the Trump administration has tried to say is not true, but it is. And the moderation of content up to and including kicking off the president of the United States from Twitter is something that Angela Merkel, when she was still in power, said, that is not something we agree with. We don't think that a private actor should be able to allow to kick off the president from a platform. We think that's only something that the government should be able to do, which is the absolute opposite of our system. And one, just to remember, it's the opposite systems. They believe that the government can regulate speech and that private companies can't. We believe that private companies can be allowed to regulate speech and that the government can't. But the other point I want to make is that that's basically a good thing. The fact that our First Amendment doesn't interfere with Twitter from saying, Trump, you're lying about election fraud, or you're lying about vaccine misinformation, and you are violating our terms of service and we're kicking you off, that is enabled by that type of good, what I would call self-regulation, is enabled by our current First Amendment structure. And so often I think people sort of bemoan, why can't we have more sort of control of First Amendment control of private actors? But if we did have sort of a First Amendment applied to Twitter as if they were government actors, then they would not be able to sort of as freely moderate their content because they would have to worry about government interference with speech. And so I think the difference that we have from the European model, the protections that we have from 230 not only work as the shield, but also enable, perhaps this is your sword metaphor, it also enable Twitter to use its sword to sort of take down speech that they don't want, or speakers that they feel violate their terms of service.
Yeah, there was a bill, I don't know where it stands currently, but it was being debated in Florida. It was constructed after Trump was removed from various platforms by the Florida GOP that essentially said the companies, the major social media companies, cannot remove a candidate or a sitting member of a candidate for a political office or a sitting representative. And I mean, it was very oddly worded. I mean, the sort of caveat that if you had a theme park that was over a certain amount of acres, you were excluded from this, clearly as a sort of nod towards Disney. But it would, of course, be dead on arrival if it ever were challenged in court. But it was also just ridiculous, because then all anyone has to do to spread just enormously harmful hate speech is just declare themselves a political candidate for office. I mean, there are plenty of city council races that would allow any number of bad actors to go register and do whatever they want with impunity. So, efforts sometimes to address some of these have gotten a little bit ridiculous, and you can see the clear harms there. One other point on regulation, I'm sure almost everyone who watches TV or spends any time on internet has seen Facebook very actively engaging in an ad campaign in favor of more regulation. And now I don't want to always be suspicious of Facebook's motives. However, I mean, there is a reason that Facebook wants more regulation, because when you have more regulation, it kind of creates a moat around them and the other big players. Because this again gets back to the wider internet. If you're a small startup social media platform that maybe employs 10, 15 people, you have a few 100,000 employees or users, if there are laws in place that you are going to be fined a certain amount of money for not taking down potentially libelous content within 24 hours, 70% of your workforce then has to be in trust and safety. And it's just impossible. So it's a barrier to entry for new digital platforms if you put in place too onerous regulations. And this is at least part of why Facebook and others are okay with a certain amount of regulation, because they know it protects them to a degree, because many of their competitors just wouldn't be able to compete if the huge amount of their workforce had to be dealing with trust and safety issues as opposed to tech development.
So one last question before we open it up to the audience is, I know David Goldenberg from the ADL spoke at the last salon about the algorithms, but I think more information dropped recently I think even today about the Facebook papers and the whistleblower and the allowing of terrorist content, drug sales, hate speech, and misinformation to flourish, while also failing to warn investors of risks. Do you think, in light of the more information we keep getting about what Facebook did, will cause additional regulations or will change anything?
I was going to.
Sorry, I'm putting you on the spot. It just happened today.
But I can say no. I'm just totally guessing here. But I think no. As disturbing as the various regulations are, or revelations from the Facebook papers and the whistleblower are, I think that, but mostly what they show is that Facebook is aware that their product causes some harms, but they're legally entitled to continue to run their business. And so, it's just like, just like a business that might, lead to a restaurant that might lead to obesity, and they know that they could cook with less butter, but they don't want to. And so, I think given our sort of very pro-business, certainly constitutional, but also sort of, legal structure, I don't believe that these continual revelations will lead to change. I think it is one of these problems that there is a lot of anger and not a lot of focus. And so what I would argue, I begin the last chapter of my book talking about Sacha Baron Cohen, who vilifies Zuckerberg and what he calls the Silicon Six for their failure to stop both Holocaust denial and other forms of hate speech. So there is this tremendous anger out there that I think is both valid and significant, but I also think that both the legislature and individuals are sort of not sure how to focus that anger. And so one of the reasons I like to be on panels like this is I would say, let's not focus the anger on encouraging regulation about content. I would say let's focus that instead on disclosure and consistency and other sorts of policies that would not interfere with our other free speech rights, but that would hopefully start bringing about some change for social media.
There is a proposal currently that has been put forth by Representative Malinowski, and I forget who the co-author of the bill is, but it essentially is another amendment to 230 that does deal with algorithms and essentially algorithms driving people towards extremist content. I don't know the sort of ins and outs of the bill, so I can't speak to it any more fluently than that, but that is something that has been proposed that gets more at the sort of algorithmic level and driving people towards harmful content rather than the content itself. I don't know where that's going to go. I think the Facebook revelations are going to be a pretty bigger problem for Facebook probably again in Europe, where there's this sort of idea of duty of care, where you create a product and you are responsible for the bad consequences. You're potentially responsible for the bad consequences that come from that product. So again, I agree with Ian. I think in the US, nothing will happen. I mean, partly because the current government has not been particularly effective at doing much of anything around internet regulation, and even sort of low-hanging fruit like the Honest Ads Act that is pretty uncontroversial hasn't moved in 4 years. So I don't think it will do much. But there are some bills currently that are starting to look more at the algorithms that the companies build as opposed to what types of speech should and should not be permissible.
And I just want to, there's an important book from NYU Press, my publisher, called Algorithms of Oppression, that talks about how algorithms are also sort of perpetrate systemic racism. I think there's a lot of really interesting research being done in that area, and I sort of intuitively believe it, even though I'm not an expert in that area at all. But again, I would say that, just because we can't necessarily regulate something, I think that would be very difficult, both constitutionally and practically, to regulate. but just because we can't regulate something does not mean, again, that we have to throw up our hands in the air and go, oh, nothing can be done about this horrible problem. I mean, I think, focusing, we can lobby, and we can, and I think in some ways, individuals sort of, marching with their feet or marching with their dollars or marching by signing off of Facebook, that, can bring about change in a much more likely way, a much more likely successful way than waiting for government regulation or waiting for constitutionally permissible government regulation. So when we see or there's research about algorithms leading towards racism or promoting racist ideals or fascist ideals, I think we can tell social media companies that we find this unacceptable and that we want them to change, and that we will, again, not use their platforms or speak out, again, in the marketplace of ideas and condemn them for their failure to take action. I think that can be quite effective. I think the legislative element of that is very unlikely to have any success.
And just very briefly, Jacqueline, because I know we want to get to the questions.
Well, actually, no, there's one more thing after. Go ahead.
Okay, but I think the point Ian made about there being other levers that we can pull that stay away from regulation. I think the number one is advertising money and the flow of money into platforms, into websites, and how unregulated that business is. So this is more of like a FTC issue, and how often advertisers are unwittingly funding hate. And by that, I mean, at this point, and I don't want to get sort of too deep in the weeds here of online advertising, but, traditional advertising, both my parents were in advertising, an advertiser selects television show and newspaper they want to place an ad. The same thing sort of exists online. It's a banner ad, but that's about 15% of advertising. Most of it, an advertiser says, I want to reach men between the ages of 30 and 50 who are interested in Republican politics. And then from there, the ad is just placed for them. And the advertiser has very little insight to where that ad is placed. Multiple bits of research have pointed to how often those ads are placed on very problematic sites, and they're funding those sites. And it's a really bad look, of course, for the advertiser when their ad appears on a site that promotes conspiracy theories or hate speech. I mean, one example, my wife works in digital advertising. She used to work for a sports marketing company selling baseball bats. I go to a lot of suspicious websites doing what I do. So my Google algorithm reads me as being, a male who's interested in baseball, but probably has some neo-Nazi leanings. And so when I go to suspicious sites, I have in the past seen her ad there. Now, clearly, she is not trying to target people going to a very problematic white nationalist site or conspiratorial site. And so there's this sort of brand reputation idea. There's also it's ad fraud in many cases. It's being placed on sort of nonsensical content aggregators. And so if advertisers really get behind this and start cracking down and ensuring that their ads are placed on reputable sites, and pressure YouTube and Facebook and other sort of walled garden sites to not allow quite as much problematic content there, that would do wonders.
I love that idea. One last question.
Taking photos of the baseball bat on the Der Stromer website or whatever, and then posting it on social media, and then saying, because we can use the tools. I mean, it's the most common free speech defense, but it's a good one. We can use the tools of greater speech to bring about the change that we want on social media. So if you post on social media, hey, bat company, why are you funding this neo-Nazi organization? They are going to take notice of that, and they are not going to like it. And they're going to go back to Facebook and say, I don't want any of my ads ever appearing on that kind of site again. And if you can't guarantee that, I'm going to take my advertising business elsewhere. So I think, people working within the current social media constraints that we have can really make a big difference.
I love these ideas. I might use them. There was one more question I was going to ask, but if Carol hasn't come on yet. So then let me just ask one more question: is should age, or Carol, do you want to start?
Well, I can start, or you can ask your question and then I'll start. Go ahead.
It was just, should there be a difference determined if someone is under the age of 18 or someone is under the age of 12? Should there be other regulations on social media sites or in the internet based on age? That was an earlier question, but I'm going to ask it now.
Well, I'll let Ian take the legal side.
Okay, from a legal perspective, first of all, we do have those restrictions. I mean, there are age, even though many people don't follow them, there are age restrictions on how old I can't remember if it's 12 or 13, to be on Instagram or to be on Facebook.
What about TikTok?
There are restrictions on TikTok too. I'm not sure what the age is, so we do have some restrictions. I would say, and the companies themselves say that we don't want people who are that young to be on it, and maybe they mean it, maybe they don't. But so one, we do have restrictions, age restrictions right now that the companies are self-imposing. But two, I do want us always to be concerned about the sort of what about the children argument. That so often, so much of censorship, of government censorship, of speech throughout our history has been the idea that we are protecting children from comic book violence, from sexual activity, from anti-religious viewpoints, and that we always, when we are thinking about sort of advocacy that is paternalistic advocacy to protect minors, that we have to make sure that we are not reducing speech to just that would be what would be fit for an elementary school class, because that would really not only limit so much of our speech, but also the very important concomitant First Amendment right of the right to receive messages. Justice Kagan talks about this in the one key social media case, Packingham, which I talk about in my book, but she talks about the right to receive information. So it's not just being able to post on social media, it's being able to hear what other people say. And if we're so concerned about kids that we're curtailing what people say, it's also curtailing what adults can hear. So I get nervous when we talk about that kind of framework.
Bret, was there something you wanted to add?
That's a better answer than I would have given, because I'm only looking at it from the perspective of a father who, fortunately, it's a decade until, at least I hope, not more, till my daughter's ready to go online. But doing what I do, I sort of look at that with terror. I mean, we know what it does to adolescents and the harm it causes. But again, I probably lean in Ian's direction if you really press me on it. So I would push hard for her not to join any platform until she's 16. Whether that should be mandated from on high, I think probably not.
Well, my 15-year-old daughter who's on Instagram would disagree with that. But anyway, we can move on to Carol's questions.
Well, let me start by saying this has been just a wonderful discussion so far, and it has stimulated a good number of questions in the Q&A box. Let me introduce myself very briefly. My name is Carol Levine. I am a past local and national Ncjw leader, and that's all I'm going to say about that. I am currently the chair of Courts Matter Illinois, which is an offshoot of Ncjw's benchmark project. And so from there, let me just start, and I'm going to not ask exactly read you the questions, but sort of try and put these questions in terms so that we can go through them fairly quickly. One of the first questions that popped up, I think, was based on our previous webinar this week. And it was a question related to the algorithms on social media, sending people to questionable websites. And the question was, is there any way to regulate that?
So yes and no. You could certainly attempt to regulate it, which I think, as I mentioned, there are bills that are in motion that touch on that issue. It's really complicated. And when I've had these discussions with engineers at Google, so the people I actually sort of trust, not their policy people who are sort of spinning it, the response is always, I don't know how to do that. At this point, we sort of think of an algorithm on Google. They're like, there are hundreds that determine sort of what content is prioritized. And no one even sitting at Google has sort of eyes into all of it. Now, again, that doesn't mean that necessarily we shouldn't look at that issue. And there was a bill introduced by Cory Booker a few years ago, like the Algorithmic Transparency Act, that deals a little bit more with what Ian was talking about earlier, which was housing discrimination and the fact that African Americans were not being shown certain housing ads on Facebook because they were allowing people placing ads to select the sort of characteristics of who they wanted the ad to appear for, which ruled out most African Americans. So I think there are ways of getting at that algorithm issue. I am not a tech developer by nature, so I don't understand the sort of deep root of the problem. And so this only other thing I'd add is just it's really complicated, because I think even at the people at the companies, if they wanted to do it, it would be a little bit challenging for them to figure out exactly why an individual person is being sent to this website versus another website, just because there's so many factors at play there.
Okay, there was a question with social media and whether or not the First Amendment can, and I'm gonna just, this is a direct from the way the question was written, can the First Amendment forbid certain ideas? And how could this function in the workplace? Is it different in the workplace than it is in writ large, so to speak?
Well, it's very different in the workplace. I can answer that. So first of all, no. The First Amendment, let me answer the first part of the question first. The First Amendment cannot forbid an idea. That is sort of contrary to sort of the whole point, I would argue, of the First Amendment is that all ideas, even those, to paraphrase Justice Holmes, even those ideas that we are sure are wrong, that fill us with dread, that seem to be dangerous, those are the ideas that, in fact, we most need to protect. And of course, somebody says, well, not Nazi ideas or not racist ideas, but people will say, and not Black Lives Matter ideas, and not gay rights ideas, and not feminist ideas, and not pro-Jewish ideas. So I do not believe that we can constitutionally permissibly allow forbidden ideas. However, it's very different in the workplace. The workplace is not government actors, and we do forbid certain ideas in the workplace. Sexual harassment law is largely, as Jacqueline pointed out on her chart at the beginning, sexual harassment laws are laws that are about speech, that you cannot say certain things to people in a way that would be sexually harassing, for example, or condition employment on sexual activity, which is another form of sexual harassment. So that goes back to the big picture dichotomy that the First Amendment does not allow the government to forbid an idea or to restrict a content-specific idea, but that private employers can be subject to restrictions on speech and, in fact, even some ideas.
Okay. We had a question about the rights of persons whose hate speech includes calls to action without being specific. Okay. Do they have rights to just issue a call to action without being very specific? Let's do something about it.
It has to be specific. Again, in the first chapter of my book, I talk about how the marketplace of ideas was involving speech, came about in a case involving an anarchist, Molly Steimer, an unsung feminist Jewish hero in my mind, who threw out anti-war leaflets from the rooftops of the Lower East Side, anti-World War I leaflets. But that was considered, inciting illegal action because she was against the war and against the draft. And so the test that sort of came out of that after years is the Brandenburg Test, that basically says that even speech advocating illegal action can only be constrained or restricted or stopped if both it is likely to cause harm and that harm is imminent. So you need both a likelihood and an imminence. Which I think is could be definitely a legal way of describing specificity. So in Brandenburg, some Ku Klux Klan people were saying they were in Ohio, and they're saying we're going to take the capital and get rid of that, I won't say the racist terms, but get rid of those pro-Black people in the White House. And we're going to kill them. I mean, they didn't exactly say it that way, but the idea was that it was their speech was considered protective because there was no likelihood that what the people were talking about in this field in Iowa or in Ohio was going to lead to, and even if it was going to lead to something, it was not going to lead to it imminently. So I'm not sure exactly that's what the person means by specificity, but that is the legal standard. It's the same legal standard that would apply to whether or not if Trump was going to be criminally prosecuted for the speech on the day of the insurrection, it is Brandenburg that would apply, and we can only restrict speech that might cause illegal action if it is specific in that way.
What if they said, I bought a plane ticket and a gun?
Yeah, probably. I mean, that's the nice thing you brought up, like, what about standards? So that's the nice thing about standards is that you don't have to be able to answer every question. I'm trying to dodge it. I mean, I think that's, I would say that if I was a judge, that's not imminent enough. That's specific, but it's not imminent enough. And then also there's a question of likelihood. Well, what's going to happen? Are you going to get on the plane with the gun? How are you going to get the gun on the plane? When you get to the place, how are you going to? So there's a lot of sort of likelihood problems there. But the standard is basically that just sort of spouting off about things that could lead to violence is not enough. And again, when we think about it in the Nazi context, or we think about it in the insurrection context, everyone's like, well, we should be able to restrict more of that speech. But again, from a more liberal perspective, any type of civil disobedience could, in theory, lead to violence. The civil rights movement was always being accused of leading to, racial violence. The Black people who were fighting for their rights were blamed for being instigators of violence, when, of course, they were the victims of violence. But the point is that so often, any type of dissenting speech is quickly threatened by people who say, well, we can stop this because it might lead to violence. And that wasn't enough for Mary Beth Tinker wearing an armband. The court said there had to be a greater likelihood and specificity of harm. And that's true in Brandenburg, and that's true at the Capitol insurrection today. So, and I would again say that's what the law is. And it's a good thing that even in those very dangerous contexts, that we don't too quickly start restricting speech based on just an undifferentiated fear of violence.
So I'm going to ask one more question, with great apologies for those others that I didn't get to, because there were many more in our Q&A box. And I actually think I know the answer to this one, but I think it's so current and it applies to a lot of things. So I'm going to see if I'm, with all of my great legal background, not being a lawyer, but heading Courts Matter Illinois, if I've got this one right. Would teaching critical race theory fall under free speech?
Absolutely. I mean, it's a big question, but absolutely is the short answer. That there is a long line of cases about sort of academic freedom and teaching and protections for academics and teachers to be able to choose their course curriculum. However, and while I think that, I talk about critical race theory in my book, in the true way it's which is applied, which is as a graduate model of looking at initially looking at the law and how the law sort of previously ignored the idea of race and yet how race is an enormous factor in determining legal outcomes. That's true critical race theory in a ridiculously brief nutshell. And what people say today about, no one's teaching critical race theory in middle school. They might be talking about slavery, but that's not critical race theory. So I would argue that there are free speech protections that should protect academic freedom in the schools. But again, that would only apply, the First Amendment only applies if we're talking about public schools. Private schools can do whatever they want. They don't, and can be, and sort of have no First Amendment protections or limitations.
Well, we have some other great questions related to the internet, related to other things. So we may be sending them to all three of you and asking you if you would reply to them, and we can get back to people with some answers. I want to take a moment just personally to thank the three of you, Ian and Jacqueline and Bret, for a really stimulating conversation before I turn the last few minutes over to the presidents of South Cook section and Chicago North Shore section, who also want to add both their thanks and want to close out what has been a fabulous series of 3 programs. And so I'm going to turn it over to Sharon and Debbie.
Thank you, Carol. I am Debbie Wiedinghoff, president of the Chicago North Shore section. The National Council of Jewish Women Chicago North Shore and South Cook sections thank everyone who has joined us during this 3-part series, Let's Talk Fact or Fiction. Please take the time to complete the short survey. I believe it's in the chat, and we will also be sending you a link to it tomorrow in a follow-up email. It is so important in today's world to understand the issues we face, what solutions are available, and how we can be manipulated by technology. We hope these sessions have provided some of this information. If you missed any of the presentations, they are available on recordings. The links have been sent out via email to all who registered. If you are interested in becoming an Ncjw member with either the Chicago North Shore section or the South Cook section, please visit our membership links listed on the summary you will be receiving. And now I will turn it over to Sharon.
Thank you, Debbie. My name is Sharon Johnson. I'm the proud president of National Council of Jewish Women, South Cook section. I want to say a special thanks to all of our presenters, Chuck and Sylvia Myers, Stephen Luckert, David Goldenberg, Ian Rosenberg, Jacqueline Carroll, and Bret Schafer for sharing their expertise and their valuable time with us. To our committee that spent so many hours discussing and preparing these programs, a well-deserved thank you for your dedication and commitment. Our chair, Jan Schwartz, committee members Deborah Borodkin, Magda Roth, Elena Marone, Meryl Gross, Beth Najberg, Carol Levine, Debbie Wiedinghoff, Debbie Pebworth, Donna Fishman, Donna Gutman, Jill Lexier, Kim Sterling, myself, Melissa Probert, Chuck and Sylvia Meyer, Harriet Choice, and Jillian Wolf. NCJW Chicago North Shore and South Cook sections appreciate your support and look forward to presenting more informative, necessary programs dealing with social justice and improving the quality of life for women, children, and families, and by safeguarding individual rights and freedoms. Please be watchful in your everyday life for attacks against your rights or the rights of others. National Council of Jewish Women has a faith in the future and a belief in action. Please do the survey, and thank you. Good evening.